by Advocate Mkhwebane. The sixth fact is that on the 7th of June, Advocate Mkhwebane wrote to the President stating that she was investigating Phala Phala and requiring him to answer 31 questions. That's the 7th of June. The seventh fact is that the letter from the President informing, the letter of the 9th of June from the President informing Advocate Mkhwebane of her suspension was prepared over a number of days. The letter was sent on the 9th, but it was prepared over a number of days. And if I can just give the Court the reference, it's paragraph 76.8 at volume 18, page 1771. The eighth fact is that on the 8th of June, a revised draft of the letter of suspension was provided to the President, and one will find that paragraph 76.6, volume 18, page 1770. The ninth fact is that this draft of the 8th of June was the final draft which the President signed the following morning, on the 9th of June. The 10th fact is that the suspension of Advocate Mkhwebane produced no personal benefit for the President. And I will come back to that in due course. It produced no personal benefit for the President because the Phala Phala investigation continued under the leadership of the Deputy, then acting, and because the President was required to answer the 31 questions, and because he did answer the 31 questions. So nothing changed as far as the President's position was concerned through the suspension. The 11th fact is that when the President made his decision to suspend, he didn't know that the parte judgment was about to be handed down. There was a bit of a fuss about this in the papers, but it's now common cause that he didn't know. And the 12th fact is that the President, again, a matter which is not widely known in the public domain, and it shows how careful one has to be about reasonable apprehensions of bias. What is not widely publicized is that the President intended to attach his answers to the 31 questions to his answering affidavit. And he didn't do so because the Public Protector asked him not to do so. She said this might compromise and jeopardize the investigation if his answers went into the public domain. And the President remains willing to make his answers publicly available, subject to the direction of this Court and the Public Protector. So that's the 12th fact, that he intended to make all of this public. And I make three initial submissions arising from these facts. All of this is common cause or undisputed. But three initial submissions arising from these facts. The first is that there can be no serious suggestion that the process of suspension was hasty or hurried. It started on the 18th of March 2022. That's when the President informed Advocate Mkhwebane that he was considering suspending her and invited her to make representations. Second, the main reason the matter was not brought to a head earlier was that Advocate Mkhwebane requested, and the President granted, several extensions for the filing of her representations. She ultimately filed them on the 26th of May 2022, about 2 months after the initial date. The delay was caused by the President's accommodation of the requests of Advocate Mkhwebane. Thirdly, and this I need to go through carefully, the evidence does not show precisely when the drafting of the suspension letter started. What the evidence shows is the following. Firstly, that the President received the final draft on the evening of the 8th of June. That's the final draft which was signed. Secondly, on the 8th of June. He received the final draft on the evening of the 8th of June. Secondly, that draft had been prepared according to the affidavit over a number of days. So it's over a number of days preceding the 8th of June that